We are starting a focused analysis today on a figure whose professional life, well, it spanned over 2 decades, at one of Canada's most respected medical institutions, the Hospital for Sick Children in Toronto.
Mm-hmm.
This figure, a pathologist named Charles Smith, he was trusted. He was trusted to speak for the most vulnerable victims imaginable, children who died under sudden or, suspicious circumstances.
Right.
Yet his work became the very foundation for catastrophic injustices, leading to numerous wrongful convictions and just, profoundly altered lives.
It's a very challenging topic, and I think we need to say that up front because the gravity and complexity of the sources. We're really examining the consequences of a massive failure within the forensic system.
And the person at the center of it.
The person at the center of it. Charles Randall Smith, he was the head forensic pathologist at Sick Kids in Toronto, Ontario from 1982 all the way until 2003. And when you just look at his tenure, the sheer scale of his influence it's immediately apparent.
What kind of numbers are we talking about?
The sources indicate he performed well over 1,000 child autopsies during that time.
1,000.
Over 1,000. And for a very significant period, he was, for all intents and purposes, the single defining authority on suspicious child deaths in the entire province.
Over 1,000 autopsies.
Yeah.
That number, it doesn't just represent volume, it represents an immense concentration of institutional trust and judicial reliance.
Absolutely.
So the core mission of our discussion today, really driven by these detailed sources, is to trace the trajectory of this failure. We need to understand not just that his work was flawed, but how. How did one expert's testimony become so central and so systemically unreliable that numerous convictions ultimately had to be systematically overturned?
And our structure for this analysis will really follow that institutional breakdown. We'll start by looking closely at Smith's background and the controversial, almost mission-driven approach he brought to forensic pathology. Then we'll examine the systemic exposure of his methods, specifically through the landmark gouge inquiry. After that, and this is the most crucial part, we'll dedicate significant time to detailing the severe human toll through the specific cases of wrongful conviction.
The people whose lives were ruined.
The actual people. And finally, we'll assess Smith's eventual accountability and the massive systemic reforms that were, forced upon the Ontario justice system as a direct consequence of all this.
All right, let's begin by looking at the man himself. The sources offer some really compelling personal details about Dr. Charles Smith's origins, which might, in part, explain the almost crusading zeal he brought to his professional life.
Indeed. It's quite a story. Smith was born in a Toronto Salvation Army hospital and was placed for adoption just 3 months later.
Oh, wow.
And this personal detail, this sense of, early abandonment, it carries significant weight when we consider his later professional obsession with protecting vulnerable children. The sources note he later spent years attempting to find his biological mother.
Did he ever find her?
He did.
Yeah.
He finally managed to contact her on her 65th birthday, but she refused to take his call.
That is a detail that is incredibly difficult to hear. It paints a picture of a childhood marked by instability and displacement, perhaps fueling an intense need for certainty, for authority, and for justice in his adult professional life.
It seems that way. His adoptive father was in the Canadian Armed Forces, which resulted in Smith moving frequently throughout his childhood. He lived in various locations across Canada and even in Germany.
So a lot of disruption.
A lot of disruption. He ultimately graduated from the University of Saskatchewan in 1975, and after training at the University of Toronto, was certified as an anatomical pathologist in 1980. He joined Sick Kids in 1981 and very, very quickly focused his specialty on pediatric pathology, specifically sudden and suspicious child deaths.
So he didn't just find a specialty. From what you're saying, he essentially created the blueprint for how this specialty operated in the province.
Exactly. Just over a decade after he arrived, in 1992, the Ontario Coroner's Office formalized this dedication. They established a specialized pediatric forensic pathology unit at Sick Kids, and Smith was appointed director.
Of course.
And what's critical to understand here is that he wasn't just directing a small department. Because of the unique nature of his expertise and the total institutional reliance on Sick Kids, he took on near-sole responsibility for investigating suspicious child deaths across all of Ontario during this period.
When you look back at that, this concentration of power, where one individual is the definitive forensic voice for an entire province on such sensitive, high-stakes cases, it just seems inherently risky. There was no robust system of independent peer review surrounding him, was there?
No, and that lack of oversight became catastrophic. His influence radiated outward, far beyond the autopsy table.
So,
The sources describe his highly active and influential educational role. He wasn't just testifying in courtrooms, he was training lawyers on how to effectively cross-examine expert witnesses.
Wait, he was teaching other people how to challenge experts like himself.
Yes, so he was intimately involved in teaching others how to challenge forensic science, while at the same time positioning himself as the ultimate, unquestionable authority in the field.
And he wasn't just training lawyers?
Not at all. He was the primary instructor for law enforcement and for medical staff, setting the standard for how to recognize and investigate child abuse. He was, in effect, institutionalizing his own perspective across the entire investigative chain, from the first responder all the way to the prosecutor's office.
This brings us to that crucial internal motivation he always cited. The sources quote him proclaiming that he had a thing against people who hurt children. He saw himself and presented himself as a champion, a moral crusader.
Right, fighting to ensure that child abuse did not go unpunished.
That moral certainty, however commendable the intent might seem on the surface, that seems to be what ultimately compromised his objectivity. What was the critical observation leveled against him that really foreshadowed the eventual downfall?
The criticism was that Smith was on a crusade and acted more like a prosecutor than an impartial pathologist.
The prosecutor.
Exactly. And that is the central tension of his entire career. An impartial pathologist must follow the evidence wherever it leads, even if it leads to an uncomfortable conclusion, like a natural death or an accidental death. A prosecutor, however, seeks a conclusion that leads to a conviction.
So his approach was criticized because he appeared to enter cases with an assumption of abuse already in his mind.
Yes, which meant he interpreted ambiguous findings through a lens of certainty that simply wasn't justified by objective science.
Can we elaborate on that? How does that prosecutorial bias actually manifest in the work? I mean, it's one thing to have a strong opinion, but how does it corrupt the forensic science itself?
It corrupts science by minimizing ambiguity and overstating certainty. When an objective finding might have two possible explanations, say a minor bruise could be accidental or it could be abusive, Smith consistently and forcefully emphasized the abusive explanation.
And he would do this in his reports, in court.
Both. He would use strong, emotionally charged language in his reports and on the stand, framing the interpretation of injuries in a way that left very little room for doubt, often to the great detriment of the accused. The sources suggest that this bias led him to ignore alternative medical explanations or even, and this is critical, normal anatomical variations in children. We will absolutely see that in the cases later.
And because he was the sole authority.
Because he was the sole authority and because the societal mandate to protect children is so powerful, this bias was just, it was accepted, and it was internalized by the entire system surrounding him.
You can imagine the societal pressure. That pressure to find a perpetrator when a child dies is immense. In a system that's desperate for definitive answers, particularly in these tragic cases, Smith offered certainty.
He did.
But as we now know, certainty that's based on faulty science is the most dangerous kind of certainty. It paves the way for the catastrophic miscarriages of justice that followed.
So, given the intense authority that Smith commanded, the initial red flags regarding his professional conduct were, well, they were surprisingly slow to develop into full systemic scrutiny. The cracks really started appearing in the early 2000s.
What were the first concrete actions taken against him by the regulatory bodies?
In 2002, the Ontario College of Physicians and Surgeons, that's the body overseeing all medical practitioners in the province, they issued Smith a caution.
A caution? What does that mean exactly?
It's a formal public reprimand that signals official concern about a physician's competence or their conduct. And this one was specifically related to his work on 3 suspicious death cases. It should have been a major institutional alert.
But the full-scale review didn't happen right away. The response seemed staggered.
It was. Following that caution, the response did escalate, but within the medical sphere. So in 2003, he was immediately removed from performing autopsies at sick kids.
Okay.
So by that year, the internal medical community had lost enough faith in his competence to sideline him from his primary function.
Okay, so if the institution knew enough to sideline him in 2003, why did it take 2 more years for the chief coroner to order a formal, large-scale review? You have individuals whose convictions were based on his past testimony continuing to sit in jail. That delay itself points to a massive institutional failure to grasp the potential magnitude of the problem.
That lag is precisely what the Gouge inquiry later addressed as a systemic oversight. The system was just so slow to connect the dots between Smith's current professional failings and the 2 decades of forensic evidence he'd already provided in criminal trials.
So when did the formal review finally happen?
It wasn't until June of 2005 that the Chief Coroner of Ontario formally ordered the review of a specific sample of his work: 44 autopsies conducted by Smith.
And these weren't just random cases.
No. The sources confirmed that 13 of those selected cases had already resulted in criminal charges and convictions. Real people's lives were hanging in the balance of this review.
A review of 44 cases. It's statistically small when you consider the 1,000-plus autopsies he'd performed. But the findings, which were released in April 2007, must have been utterly devastating to the reputation of Canadian forensic science.
They were shocking. The 2007 review identified substantial professional problems in fully 20 of the 44 autopsies they examined.
20 out of 44.
20 out of 44. That is nearly a 50% failure rate in the sample. The problems ranged from, misinterpretation of injuries and the failure to consider alternative explanations to poor documentation and critically improper handling of physical evidence.
When you're facing findings that suggest convictions in nearly half of sample cases were based on flawed forensic evidence, the government has no choice. They have to act decisively.
And that's when the political response crystallized. Ontario's Attorney General at the time, Michael Bryant, immediately announced a full public inquiry into the entire state of pediatric forensic pathology in the province. This wasn't just about Charles Smith anymore.
Yeah.
It was an acknowledgement that the system that enabled him to operate for 2 decades without any real oversight was fundamentally broken.
So let's focus on that inquiry, the Gouge inquiry. What was its ultimate goal, and what were the most damaging conclusions it presented about Smith himself?
The Gouge inquiry, which was led by Justice Stephen Gouge, began hearing evidence in November of 2007. Its scope was vast: to investigate the failings of the system and, crucially, to recommend comprehensive reforms to ensure the integrity of forensic evidence moving forward.
And when the final report was issued the following year,
It pulled no punches.
what were the specific characterizations of Smith's work? How did they describe it?
The inquiry concluded that Smith had made fundamental errors. And this means the errors weren't minor procedural mistakes. They went to the very heart of his scientific process and his judgment.
And it went beyond just incompetence, didn't it?
It did. The findings introduced a much darker element of deliberate dishonesty. The inquiry determined that Smith had actively misled his superiors at SickKids and had made false and misleading statements while testifying in court.
That distinction between incompetence and deliberate deception, that is vital. It suggests a knowing manipulation of facts or interpretation to achieve a desired outcome, which reinforces that idea that he was acting as a prosecutor, not an objective scientist.
Precisely. His testimony was found to be highly unreliable and, in some instances, intentionally deceptive regarding his actual findings or the context of the injuries. The Gouge report pointed out Smith's pattern of being too zealous, of failing to maintain objectivity, and acting way beyond the scope of his expertise. This confirmed that the institutional trust placed in him was systematically abused.
And the sheer weight of these findings meant what?
It meant that every single case in which Smith had played a pivotal role now had to be meticulously re-examined, initiating the long, painful process of overturning convictions.
We must approach this next section with immense sensitivity, as we are now discussing the irreversible human cost paid by people whose lives were destroyed by these fundamental errors. We're talking about stolen years of freedom and the complete rupture of families.
The cases, they just illustrate the deep tragedy. The evidence provided by Smith wasn't just a piece of evidence in these trials. It was often the single, decisive piece of forensic proof that guaranteed a conviction, especially in the absence of other physical evidence or any direct witness testimony.
Let's start with William Mullins Johnson, who spent over a decade in prison for a crime he didn't commit, primarily due to Smith's assertions.
William Mullins Johnson was found guilty in September of 1994 of the first-degree murder of his 4-year-old niece, Valen Johnson. He was babysitting her. Smith's involvement was comprehensive and just devastating. His testimony played a major role in determining the time of death, the cause of death, and, most importantly for the jury, his conclusive assertion that the girl had been sexually assaulted.
And this detail, the sexual assault finding, that's central to the injustice here, isn't it? It turned what could have been a tragic accident or a natural death into a horrific, intentional crime in the eyes of the court.
Absolutely. The defense in the original trial suggested that Valen, who suffered from some severe health issues, including frequent vomiting and diarrhea, may have died of natural causes. But Smith's evidence was just so powerful. And crucially, the sources note that he was the only consultant who concluded the girl had been sexually assaulted.
The only one.
The only one, a claim that was strongly refuted by the experts who later reviewed the case. And despite these doubts, Mullins-Johnson's conviction was upheld twice on appeal, even reaching the Supreme Court of Canada in 1998.
The attempts to clear his name highlight an astounding failure of forensic management tied directly to Smith. They couldn't perform modern DNA tests because the crucial tissue samples were missing.
That's maybe the most unbelievable detail of the entire case. The tissue samples, which were essential for the advanced DNA technology needed to definitively prove or disprove the sexual assault claim, they couldn't be located for years.
So where were they?
Astoundingly, it wasn't until 2005, 11 years after the conviction, that the missing tissue samples were finally discovered. They were sitting in Dr. Smith's office.
His office.
Yes, this was not a failure of institutional archiving. It was a failure of the expert to properly secure and hand over critical evidence that was vital to the accused's defense.
11 years of freedom lost, while the exonerating evidence just sat in a box in the pathologist's personal workspace.
And the recovery of those samples, it paved the way for justice. Mullins-Johnson was released on bail in 2005. By October 2007, an independent review of those samples confirmed there was absolutely no evidence of sexual assault or trauma.
None at all.
None. The evidence Smith had provided, the evidence that convicted him, was scientifically baseless. The Ontario Attorney General publicly declared that the conviction cannot stand.
He was formally acquitted by the Ontario Court of Appeal in October 2007, and after serving 13 years for a crime that never even happened, he eventually received $4.25 million and a compensation settlement from the government in 2010-6. But, that money, it's essential, but it can never compensate for the years that were stolen from him.
No. And that profound injustice is replicated, though with a different set of consequences, in the case of Sherry Sherritt. Her case highlights Smith's catastrophic failure to distinguish a normal anatomical structure from a serious injury.
Sherry Sherritt was convicted of infanticide in 1996, following the death of her 4-month-old son, Joshua. He was found deceased in his bed. Her conviction stemmed directly from Smith's authoritative opinion that the child had a skull fracture and had been smothered.
She was sentenced to 1 year in jail and 2 years probation, and she ultimately served 8 months of that. But the penalty went so far beyond the prison term. Children's Aid Society removed her older child. And in a desperate, heartbreaking attempt to secure a stable life for that remaining child, she felt compelled to agree to put him up for adoption and forego all physical contact with him until he reached the age of 18.
The systemic pressure, built entirely on Smith's flawed findings, forced her to make an absolutely incomprehensible choice.
It's the definition of irreversible damage.
What did the later review reveal about Smith's specific forensic error in this case? How could he have been so wrong?
The error was, it was a fundamental failure of pathology. A later exhumation and examination of Joshua's body revealed conclusively that there was no skull fracture.
None. So what did he see?
Smith had misinterpreted the normal suture lines, the fibrous joints that naturally exist between a baby's developing skull plates. He mistook those for a traumatic injury. These lines are a standard, non-pathological feature of infant anatomy.
He essentially mistook the child being a child for being a victim of trauma.
That's exactly it. An error that simple, yet committed by the province's leading pediatric pathologist, and it destroyed her life. When the Ontario Court of Appeal finally acquitted her in December 2009, they described the initial conviction as profoundly regrettable.
We turn next to Louise Reynolds. Her case didn't result in a conviction, but it did lead to nearly 2 years of pretrial custody, and significantly, it established a groundbreaking legal precedent regarding the accountability of forensic experts.
Yes. Louise Reynolds, a single mother, was charged in 1997 with the second-degree murder of her 7-year-old daughter, Sharon. The girl had died from over 80 stab wounds inflicted by scissors. The Crown's case relied very heavily on Smith's 10-page autopsy report and his testimony, which pointed toward a human attacker.
However, this is one of the cases where external experts intervened relatively early, which led to the collapse of the Crown's case before a conviction.
That's right. The case began to unravel in late 2000, and it collapsed entirely in January 2001. A critical mass of experts, including experts initially called upon by the Crown itself, began to contradict Smith, and their collective conclusion was startling.
What did they find?
They concluded the injuries were consistent with a powerful dog attack, likely inflicted by a pit bull that was present in the house, rather than a human assault.
So once again, Smith had incorrectly characterized the trauma, leading the entire investigation down the wrong path, right toward accusing an innocent mother.
She spent 22 months in custody, that's nearly 2 years, before the murder charges were abruptly withdrawn in 2001. Though she avoided conviction, the time in jail and the public accusations severely traumatized her, and this led to her groundbreaking legal action.
So let's discuss that legal precedent. The concept of Crown immunity often shields officials, including expert witnesses, from being sued for statements they make during testimony. How did Reynolds overcome this?
This is a really critical legal concept for you, the listener, to understand. Crown immunity generally protects witnesses, including forensic experts, from being sued over their testimony given in court. The idea is to preserve the integrity of the courtroom process.
Right, so they can speak freely.
Exactly. However, Reynolds' legal team argued that the faulty science occurred before the testimony. In March of 2007, the Court of Appeal issued a ruling allowing her to sue Smith and other experts. This was groundbreaking because the court distinguished between protected testimony and the faulty, negligent preparation of the underlying work, the reports, and the evidence.
That ruling creates such a vital check on expert witnesses. It basically tells them, you might be protected for what you say on the stand, but you are absolutely accountable for the integrity and the competence of the preparation work that gets you there.
It was a crucial shift toward expert accountability, confirming that the preparation of forensic material must meet rigorous standards, regardless of any eventual courtroom protections.
We also have to address the tragic case of Tammy Marquardt, whose conviction resulted in the loss of her parental rights, another devastating permanent consequence.
Tammy Marquardt was convicted in 1995 of killing her 2-year-old son, and tragically, the boy suffered from epilepsy. Smith's testimony was the linchpin of the prosecution's case. He concluded that the boy's death was caused by non-accidental means, specifically strangulation or smothering.
And the sentence?
She was sentenced to life in prison, and the familial tragedy was compounded when her 2 other children were taken from her and subsequently put up for adoption.
The weight of that loss, the complete destruction of her family unit due entirely to unreliable forensic science, is just staggering.
She spent 15 years in custody before the post-gouge review mechanism began to address her case. Her conviction was finally set aside by the Ontario Court of Appeal in February 2011, specifically because Smith's testimony was deemed unreliable.
And the charges were eventually dropped.
Prosecutors initially considered a retrial, but the charges were formally withdrawn in June of 2011, acknowledging the insurmountable weakness of the original forensic evidence.
These 4 cases, they really illustrate the depth of the tragedy. But we have to remember that the systemic review extended to dozens of other families who faced criminal accusations based on Smith's work.
We can look at Maureen Laidley, for instance. She was charged with killing her boyfriend's 3-year-old son in 1998. She maintained that the boy had accidentally slipped while jumping off a couch and hit his head on a marble coffee table.
A plausible accident.
A very plausible accident. But Smith emphatically asserted that such injuries could not have resulted from the mechanism she described. That led directly to her arrest and charges.
And what did subsequent expert review show?
Outside experts quickly contradicted Smith. They confirmed her account was fully consistent with the nature and the severity of the boy's injuries. The charges were abruptly stayed when the Crown realized they simply could not proceed with Smith's contradicted evidence. This highlights his tendency to inject a high degree of confidence into his opinions, even when basic mechanics or external factors suggested otherwise.
And then there's the case of Anthony Capuado and Angela Vino, which shows the procedural chaos Smith created, which fundamentally undermined the accused's constitutional rights.
Yes, they were charged in 1997 with murdering their infant daughter. In this instance, the flaw wasn't necessarily the interpretation of the body, but a catastrophic delay. Smith took more than 7 months to prepare his initial autopsy report.
7 months.
7 months. A judge ultimately ruled that this delay violated the couple's constitutional right to be tried within a reasonable time frame, and that led to the charges being thrown out. So his procedural negligence directly derailed justice, independent of the quality of his science.
It's important to acknowledge the long-term reverberations of this, affecting people who felt pressured decades earlier to accept plea deals based on Smith's initial reports.
Absolutely. Consider Dinesh Kumar. He faced a second-degree murder charge back in 1992, but he pleaded guilty to criminal negligence causing death and served a short sentence of 90 days. His conviction was part of the post-gouge review process.
Even though he had accepted a plea.
Even though he'd accepted a plea, the integrity of the evidence was still suspect. He was finally acquitted by the Ontario Court of Appeal in January 2011, almost 2 decades after that initial plea.
And similarly, Maria Shepard, who pleaded guilty to manslaughter in 1992 in the death of her stepdaughter.
She served 2 years less a day. Her life was defined for over 2 decades by this conviction. Based on the overwhelming evidence of Smith's unreliable forensic opinions, her conviction was struck, and an acquittal was entered in February 2016.
25 years later.
25 years. 25 years of living with the shame, the legal consequences, and the emotional toll of a crime she did not commit. These long-delayed exonerations, they underscore that the victims were not only those who fought Smith's evidence tooth and nail, but also those who were so overwhelmed by the perceived authority of his science that they just capitulated.
Yeah.
So following the loss of institutional trust and his removal from autopsies in 2003, and then his subsequent resignation from Sick Kids in July 2005, Dr. Smith actually attempted to resume his career. But his history of misconduct followed him.
So he didn't just resign and disappear. He tried to actively practice medicine in another province without disclosing the cloud of investigation that was hanging over him.
That's exactly correct. He immediately secured a position at Saskatoon City Hospital in Saskatchewan. The critical error he made, the one that led to his continued professional troubles, was failing to disclose to the licensing body in Saskatchewan that he was actively under investigation for professional misconduct back in Ontario.
And that failure of disclosure led to his rapid dismissal from the Saskatoon Hospital when the information finally surfaced.
He was dismissed in December of 2005. Now, he did successfully appeal the dismissal based on some contract technicalities, but he was never reinstated because he couldn't obtain the necessary license to practice medicine in Saskatchewan, given the revelations.
So he was facing professional discipline on multiple fronts.
Yes. He eventually pleaded guilty to a charge of unprofessional conduct with the College of Physicians and Surgeons of Saskatchewan, specifically for that non-disclosure of the Ontario investigation.
So he's facing discipline and the loss of his license in multiple provinces because of his deceitful actions surrounding the investigation. What was the final definitive step in terms of professional accountability in Ontario?
The final hearing occurred on February 1st, 2011, before the College of Physicians and Surgeons of Ontario. And given the overwhelming evidence presented by the Gouge inquiry regarding his negligence, his incompetence, and his deliberate attempts to mislead, Smith was permanently stripped of his medical license. Permanently. The findings cited his behavior as disgraceful conduct, and this act formally and permanently ended his career as a physician in Canada.
And as a part of historical curiosity, what is his current status? What do the sources say?
As of the most recent source material we have, which dates back to 2017, attempts by investigative journalists, notably the CBC, to locate and contact Smith had failed. His whereabouts remain unknown. He seems to have effectively vanished from the public eye after the disgrace of the inquiry.
While his personal accountability was significant, the enduring consequence of the Smith scandal lies in the sweeping systemic reforms mandated by the Gouge inquiry. What institutional lessons were enshrined in that final report?
The Gouge report, released in October 2008, it served as the ultimate catalyst. Its core conclusion was powerful. The 20 problematic cases it had identified proved that fundamental flaws existed not just in Charles Smith, but in the entire framework for handling suspicious child deaths across Ontario.
So it sounds like the key lesson was the danger of centralized, unchecked power in forensic science.
Absolutely. The report led to the creation of a formalized, highly regulated system for pediatric forensic pathology. It stressed the need for rigorous peer review, for mandatory consultation, for standardization of reporting, and for clear lines of institutional accountability.
Reforms designed to ensure no single expert could ever again hold that kind of power.
Exactly. To ensure that no single expert could ever again hold definitive, unchecked authority over an entire province's child death investigations. The system was forced to mandate objectivity and transparency.
And the institutional commitment, it extended beyond just reforming the pathology department. It initiated a massive re-examination of other controversial areas of forensic science in the province.
Yes, and that speaks to the integrity of the process. Following the Gouge recommendations, the chief forensic pathologist for Ontario immediately ordered a broader public inquiry into 220 cases of shaken baby syndrome to investigate potential wrongful convictions tied to those specific diagnoses.
So they were looking for similar patterns of overcertainty.
Yes. It signaled an awareness that the issues of overzealous, biased, or inadequately peer-reviewed science extended beyond Smith's immediate purview. It was a commitment to purging the system of potentially unreliable forensic diagnoses.
Finally, we should acknowledge the compensation provided to the victims of these catastrophic failures. While nothing can truly replace lost time, the government did attempt to formally recognize the harm done.
It did. Beyond the large individual settlements like the $4.25 million granted to William Mullins Johnson, the government established a mechanism for wider acknowledgement of the profound suffering. Individuals who were wrongly accused, charged, or convicted based on Smith's faulty work were entitled to a standardized recognition payment of up to $250,000. This was a necessary step to formally acknowledge the state's failure and the injustice inflicted upon those families.
This exhaustive analysis of the Charles Smith scandal, it really demonstrates the profound fragility of justice when it relies on unverified expert opinion. The system had to painfully re-examine 2 decades of work to undo the damage, illustrating the necessity of robust checks and balances in any system where expert testimony holds the power of life and death, or freedom and incarceration.
And we've spent some time today discussing the case of Louise Reynolds, who successfully sued Smith and others by drawing a crucial legal line between protected courtroom testimony or Crown immunity and the faulty preparation of the work itself. That ruling forced accountability further up the chain into the pathology lab itself. And it raises an important question for you, the listener, to consider as you reflect on this entire case. If the pursuit of justice requires expert witnesses to maintain absolute neutrality, what ongoing mechanisms, beyond the threat of being sued for preparation negligence, are necessary to ensure experts feel the ethical obligation to report uncertainty rather than manufacturing the certainty the state desires? The gouge inquiry fixed the system, but that ethical line remains an ongoing, personal responsibility for every single expert.
Thanks for listening.